Thanks, Steve. Great to be here. See a lot of friends and colleagues. So I want to talk about one aspect of civil litigation in terms of vindication of civil rights, a case we've been litigating in Philadelphia, Bailey versus City of Philadelphia, which deals with stop and frisk practices. But I want to put it, and we could use a lot of different examples for how litigation may or may not work in terms of police reform, but I think Bailey is an instructive case and will kind of dovetail with what is going on in Newark as well with the governmental intervention. So let me frame it this way. I want to give a little background on stop and frisk law, very little, not a lot of doctrine here. Talk about what kind of policing that is, what kind of problems it raises, and then talk about our litigation and what we've learned from the litigation in terms of these practices. So let me kind of sketch it out a little bit first, and then I'll go into what we've actually learned in that litigation and some comments on whether it's effective or not. So 1968, almost 50 years ago, the U.S. Supreme Court for the first time said that police, although they had been doing it for many years before, that under the Fourth Amendment, which normally requires probable cause to arrest somebody, to search somebody, the Supreme Court was convinced that the police also had the power under the Fourth Amendment to stop people, not to necessarily arrest them, but a short detention, and to frisk them in certain circumstances, not on probable cause, but on something less than probable cause, what the court called reasonable suspicion. Something more than a hunch, something less than probable cause. Terry was kind of a classic case where the police officer saw three men he thought were casing a store for a possible robbery. They were concerned about a violent crime, possibly gun possession, eventually confronted the men, frisked one of them, found a gun. That's the case that went to the Supreme Court. And 8-1, somewhat surprisingly, this was the Warren Court, the most liberal court, right, in the history of the nation. 8-1, U.S. Supreme Court, Chief Justice Warren wrote the opinion, said that the police had the power to stop in that kind of situation, to ask some questions about what the people were doing, even though there was no evidence at that point that any crime had occurred. But it was, in some ways, a kind of a vindication of proactive policing. That is, police intervening before they get a report of a crime. It's one thing a police officer could sit in his car and wait for a report of a robbery and then respond, but probably we want police to do more. And I think that, in part, what motivated the Supreme Court was changes in policing, proactive policing. It was also decided in '68 at the time of a lot of conflict in this country, concerns about gun violence, and so on. It was decided same year that both Martin Luther King and Robert Kennedy were killed by guns, and I think all that was in the mix. For the past 50 years, stop and frisk has been vigorously engaged in by police departments. And during that same period of time, the Supreme Court has expanded the power to stop and frisk in a variety of ways. They've said it can be done not only to investigate possible future crimes, you think somebody is up to no good, but also to investigate crimes that may have occurred. You can stop people on less than probable cause, and also expanded it to every type of offense, including a huge amount of quality of life offenses. So it's not only the power of the police to intervene when they think some violent crime may occur or that somebody has a weapon, but also in situations where there's no real possibility of violence, very minor crimes. The police have this power to intervene based on reasonable suspicion. So two standards: reasonable suspicion to stop somebody and ask some questions, and then secondly, and I want to make this clear, the court also said you can also frisk that person, but only if independently you have reason to believe that the person's armed and dangerous. That is, not every stop would necessarily give the police the power to frisk. Not surprisingly, police departments, which had already been doing this, this became a major staple, as I say, of proactive policing or quality of life policing, stop and frisk. And just to give you some idea about the data, probably a lot of you are familiar with the Floyd litigation in New York, the stop and frisk case that went to trial in New York concerning both Fourth Amendment questions about whether the police were stopping people without reasonable suspicion and whether there was racial bias in the way the police were stopping people. Just to give you an idea of what kind of practice we're talking about, New York had was keeping data. A lot of places had not kept data until that time in terms of police stops. In fact, most jurisdictions, if you went to them police departments, they wouldn't be able to tell you how many people they stopped and frisked. The only data they kept is if the frisk led to something and we had some criminal prosecution. So we had very little idea, but New York was actually keeping that data. The case that went to trial dealt with 7 years of stop and frisk, 2004 to 2011. And during that period of time, the New York Police Department made 4 million pedestrian stops. That's recorded stops, and I'm sure there were another million that may not have been recorded. So when you think about it, that's a huge number, right? A huge number of police interventions in terms of the stops that were made. And also not surprising that given the nature of policing and proactive policing and the debates both in police departments and academia and the courts, there were some people that thought, as one law professor wrote 40 years after Terry was decided, it's the perfect doctrine. It's the perfect Fourth Amendment doctrine that gives the police the power to intervene and frisk. They can't do it just randomly. They need some reason. And others who criticize stop and frisk for a whole variety of reasons. Intervention, racially biased, and with a huge cost to community-police relationships. And so you had this huge divide, right? Was it really working well? Was it effective? Was it bringing down crime? The advocates for stop and frisk in New York, for example, pointed to the huge drop in crime in New York from the period of the mid-1990s to 2012, and no question about it, homicides during that period went down 90% in New York. In the early 90s, they were running about 2,400 a year. They're now running about 350 a year in New York. And so, of course, those who advocated for stop and frisk said a lot of the credit goes to that kind of practice. No doubt some policing in New York had its effect, probably other things as well, because in other places, and I'll talk about Philadelphia, where we had as much of a stop and frisk practice, crime did not drop that much. So we had the debate, right? Is this effective, and is it constitutional? The Floyd litigation wound up, as you know, Judge Scheindlin, who you clerked for some years ago, ruled 3 years ago that the New York stop and frisk practice program violated the Fourth Amendment based on evidence that there were a significant number of stops where the officer had no reasonable suspicion to stop or to frisk. And also, which got a lot more publicity, she ruled that it was racially biased, that the huge disparities between the number of minorities who were stopped and whites that were stopped compared to the population, well, that didn't prove racial bias by itself. When you did very sophisticated regression analysis and took into account other reasons for that kind of disparity, she found that there were not sufficient reasons to think that police were not stopping minorities because they were minorities. There was other direct evidence of racial bias as well. Police officers who testified that their lieutenants and sergeants told them to stop the usual suspects, so on and so forth. So that obviously was a very controversial ruling. As you saw the debates this year, there was a little back and forth about stop and frisk in the second debate. Everybody got it wrong. The moderator got it wrong. Trump got it wrong. Clinton got it wrong. But obviously an issue that's grabbed everybody's attention. Is it good law enforcement? Is it worth it? Does it bring crime down? Or does it really hurt the police more than it helps in terms of community efforts? Well, the problem there, of course, is we don't know because nobody's really looked at the data very well. Floyd was a case that finally looked at it. We had a similar situation in Philadelphia, which brings me to the Bailey case that we litigated in Philadelphia. And the background very quickly was that in 2008, when Mayor Nutter first ran for mayor in Philadelphia during a period of a significant rise in violent crime in Philadelphia, he ran on a platform of more stop and frisk, not as if the police department wasn't already doing stop and frisk, but said we should be doing more. That's the way to get guns off the street. That's the way to control for violent crime. And it's one of the campaign promises he kept, because from the period of 2008 to 2011, the number of stops in Philadelphia increased by about 40%. In 2009, the police were recording 260,000 pedestrian stops in Philadelphia. And when you think about that compared to New York was running about 700,000, but New York's a city 5 times the size of Philadelphia in population. Philadelphia was stopping more people per capita than the New York police were at that time. And we, kind of civil rights organizations, plaintiffs' bar and so on, were getting a lot of complaints from people about multiple stops without reason, almost all from Latino and black persons in the communities in Philadelphia. Started to investigate, looked at the numbers, spoke to our lead plaintiff in the Bailey case is Mahari Bailey. He's a lawyer in Philadelphia, black lawyer, who was stopped 5 times in 1 year. Some automobile stops, from car stops, pedestrian stops. As he explained, each stop, there was no grounds for the stop. He was never arrested, no contraband was ever found. He was the lead plaintiff, and we had several other plaintiffs who had been subjected to multiple stops. We filed a lawsuit. We looked at the data. We were able to get certain data because the police department was keeping, every time somebody was stopped in Philadelphia, the police had to fill out a form in which they had the biographical data of the person they stopped, and they also had to give a reason they had a narrative, reason for the stop and reason for the frisk, right? So you could test that against what the Fourth Amendment requires. We looked at a lot of that data. It looked like a lot of those stops were without cause, and on its face, we had huge racial disparities. Philadelphia, at this point, is about 44% black and white, and about 9% Latino, 4% Asian, right? So black and white populations fairly similar. When we looked at the stop and frisk, when we were getting ready for litigation in 2009, 2010, the stop and frisk were running about 85-90% minorities. Again, doesn't necessarily prove, right, that there's racial bias. It could be there's more crime in black neighborhoods. It could be there are more police assigned there, so there's more police activity. There could be other reasons that could explain that. But we certainly, prima facie, saw that there was that huge disparities. We filed a class action lawsuit on behalf of 10 plaintiffs seeking to represent a class. And the city looked at it, I think internally, started to look at their records. One of the problems was, yes, they increased stop and frisk dramatically, but nobody was watching as to what was going on. There was simply no accountability in the department as to looking at documents, seeing if the stops were good. And almost immediately, the city suggested that we discuss settlement. We did get a settlement. We have a consent decree. And as part of that consent decree, one of the most important parts was a requirement that the city keep an electronic database of all stops in Philadelphia, which would be accessible to our side, accessible to the department, so we could measure, right, pretty well what they were doing, how much stop and frisk activity there was, and also the results, both in terms of race. And we'd be able to look at each of these forms, now can't read all of them, there are hundreds of thousands, to determine whether there's compliance with the Fourth Amendment. And this, this is a lesson in big data. Big data is now becoming a huge issue in a lot of parts of our lives. I mean, I get to feel that algorithms are going to control the rest of our lives one way or another, right? Some kind of actuarial performance that will tell us what to do or not to do. But the police have been using big data for a while. You think about CompStat in New York in terms of crime investigations. Where does crime occur? Let's look at the data, real time, send police officers there. But again, an area in which there's a lot of differences when you start using algorithms and actuarial instruments. Are they fair? Are they effective? Do they really predict in a fair way what's going to happen in the future? But we are in an era of big data, and sometimes big data can show us a lot. And it's shown us a lot in the Bailey litigation. So let me just give you a survey of what we found. And significantly, the agreement in Bailey was that plaintiff's side would get this data. The city police department's audit division would look at the same data. We would each quarter of each year take a random sample of the stops that were made. We couldn't look at every stop, it would be too many. We'd review those stops, see if there was reasonable suspicion under the Fourth Amendment, see what the hit rates were, see how effective it was, and also to do benchmarking for possible racial bias. So let me just give you an idea of what we found, which we would have had no idea about without this data. Again, this debate that was going on for many years was in a vacuum. It works, it doesn't work, but really we had no way to measure that. And so the data becomes, I think, quite significant in that analysis. And it becomes particularly significant in terms of analyzing ultimately whether the Supreme Court has gotten it right in all its cases where it talks about what is reasonable suspicion and what is not. When you read those cases, in almost every case the court says, well, it makes common sense, right? If somebody's in a high crime area and they run, they're probably up to no good. It makes common sense that if an officer sees somebody late at night with a bulge in his pocket, he might have a gun, right? It makes common sense, and all their cases are phrased in common sense. And they say, we don't have any empirical data, right, to back it up, but it kind of makes common sense, and that's sufficient for reasonable suspicion. And so the power of data is it can test, right, those assumptions of common sense. So let me tell you what we found in Bailey, and stress the fact that after at least a couple of years, we were on the same page as the police department. Our audits and the city police department audits were showing pretty much the same thing. And I'll talk about the audit we did in 2015. Again, we looked at a couple of quarters of activity. We took a random sample of the stops that were made. We looked at 2,400 stops. And what we found is, I say, what the police department found as well. Of those 2,400 stops, 2/3 were with reasonable suspicion, but a full third were without. Right? So a third of the people being stopped in Philadelphia, and this is based on what the officer was writing down. This is not a credibility question. We took at face value when the officer said, I stopped the person because of X, that's what we took as, we didn't say, but well, maybe he's not accurate in that. We took that as a fact. Even with that, we found a third of the stops were without reasonable suspicion. More significantly, when we looked at frisks, and frisks didn't always follow, we found that with respect to frisks, 50% of frisks were without reasonable suspicion. We also found significantly very low hit rates. Stop and frisk is credited with taking guns off the street and with getting arrests. It turned out both in New York and Philadelphia, fewer than 10% of all stops, and we're talking about millions of stops, right, between the two cities. Fewer than 10% of all stops resulted in any kind of citation or arrest. In other words, over 90% of the people who were stopped either were doing nothing wrong or were doing something so minor that the officer just let them go. Most significant with respect to hit rates, though, is the question of frisks, right? Because that's where the officer is saying, my observations lead me as a reasonable officer to believe that this person is armed and dangerous. Now, it's hard to quantify what that means, right? And the courts have never done it. What is reasonable suspicion that somebody is armed and dangerous? Is that a 20% chance, 30% chance, 15% chance? A lot of debate among judges and academics as to what that was. What we have found consistently in Philadelphia, and what Floyd found in New York, and what other cities have now found when they're looking at this data, is a vanishingly small hit rate for weapons. So let me just give you the data in Philadelphia. Over a couple of quarters, we looked at, in 2015, we looked at 340 frisks, right? This is where the officer says, based on what I saw, this person is armed and dangerous. Guess how many guns were seized? 10, 20, 50? Three guns out of 340 stops. Less than 1%. Less than a 1% hit rate for guns, which calls into question a lot of things. Is the officer saying, accurately putting down what the officer saw? More important is the officer, because the officer is frisking, often giving good reasons for the frisk according to the Supreme Court. So for example, let me give you one thing. When we drilled down deeper, when we started to see this data, I asked our statistician to pull every case in which an officer said, I frisked that person because there was a bulge, right, among other things. Permissible stop, I saw a bulge, I thought that might be a weapon, it was late at night. I frisked them. Bulges turned out, in one quarter we had 50 bulges, not a single gun was seized, right? 40 cell phones, no guns. Now, I've been carrying a cell phone on my hip in my pocket for 20 years in Philadelphia, I've never been stopped. But perceptions are differently. When a police officer looks at me, walking down the street with a bulge in my pocket, says, old white guy, probably no harm, right? We're not gonna stop him. I see a young black kid at night in North Philadelphia, a bulge means something else, right? But it turns out, even under that rationale, bulges don't, right? That was quite significant. And feeds into this question is how effective is this program, right? If we're only pulling a few guns off the street, are we paying too much in terms of police-community relations? I only have about 2 more minutes, so let me just summarize very quickly what we found on the race side of it. What I just told you is what we found out on the Fourth Amendment side. A lot of stops without reasonable suspicion, a lot of frisks that produce nothing. Very questionable about whether these predictive qualities the Supreme Court ran. Men running in a high crime area from the police when they see them, or avoiding the police. Again, very, very low hit rate in those situations that anybody's carrying a weapon. And what we found on the race side, just to summarize very quickly, and we can come back to this, is we had an expert, we did very sophisticated regression analyses on the data. As I say, wide disparities, 80, 85%, 90% of the stop and frisk of minorities. When you take into account crime rates, take into account police deployment patterns, take into account social conditions, 8 or 10 different regression factors. As in the Floyd litigation, our expert and the city's expert both found that there were unexplained racial disparities, right? Again, probably not intentional race discrimination, for more implicit bias. Could at least look at people differently based on race, I think, and act differently. And I think the data shows that. All of which doesn't mean that stop and frisk policing isn't good policing. There have been some improvements in Philadelphia. The data I show you for the last couple of years is actually better than when we started. The number of stops are down, which is a good thing. I think the bad stops we're starting to eliminate. I'm not against proactive policing. I think the police should intervene in certain situations. But the data gives us a lot more information about what works, what doesn't work. And ultimately, if I think for police officials, even if you got it to the point where most of the stops were with reasonable suspicion, right? They're doing it properly under the Fourth Amendment. We eliminate racial bias if we can, even assuming we can get to that point. Then the question is, the trade-off between effectiveness in policing and the continued concern about police-community relations. There's questions about procedural justice, how these stops are done. And let me just give you one final data to throw into this whole mix about effectiveness. New York City, that became a huge political issue, right? Mayor de Blasio was elected on a kind of anti-stop and frisk program. In New York City, the number of stops has dropped from 700,000 a year in 2011 to last year the police reported 40,000 stops in New York. Hard to believe it's that huge a drop. Hard to believe that. I think some stops may not be being recorded. Maybe some of those stops are turning into arrests. But that's like over a 90% reduction in New York in the stop rate. And during the same period of time, no increase in violent crime. Now, doesn't mean stop and frisk wasn't effective in controlling violent crime when they did it, but it calls into question about how necessary that tactic is. All of which is just a view of litigation, right? It's a view of litigation on how you try to reform a police department, but the bigger lesson for me is what this kind of big data shows and how we ought to be thinking about using that in the future.
Great, thank you very much. Ms. Comizzoli.
Thank you. It's a pleasure to be here today. My boss, Paul Fishman, is very sorry he couldn't be here, but I am more than happy to share with you our experience in helping to reform the Newark Police Department. But first, by a show of hands, I'm wondering, has anyone in the room ever lived in Newark, New Jersey? Has anyone ever worked in Newark, New Jersey, or gone to school there? Okay. Has anyone ever visited? Okay, good. So you may know, Newark is 350 years old, and it has a lot going for it in terms of arts, cultural activities, sporting events, great restaurants. But it is also a very challenged city. It's a very high poverty rate, has a very high crime rate, and a tremendously challenged police force and tense police community relations. One of the things I'll talk about in a bit when I talk about the investigation we did is the fact that this city is 270,000 people in it, 54% of whom are Black. But when you look at the number of stops and arrests that we looked at in our investigation, we found that 80% of the people being stopped or arrested by the Newark Police Department were Black. Now, we were unable to determine if this was intentional or whether these stops and arrests were legally justified, but what we do know is that this disproportionate impact really shapes the interactions of Black residents with the police force and erodes community trust, which actually makes the job of delivering police services less efficient and more dangerous in Newark. So this is a very challenged department. And back in 2011, the United States Attorney's Office for the District of New Jersey, in conjunction with the Civil Rights Division of the Department of Justice in Washington, launched a joint investigation of the department. One of our reasons isn't in the U.S. Attorney's Office just to ensure constitutional policing, but another one of our missions is to ensure that a police force with whom we partner on gun and drug and violent gang cases in the city of Newark is a well-run department, because we are going to rely on these officers. We have to rely on their credibility. We have to rely on their report writing in some of our gun and gang and drug trials. So we have a lot of interest in seeing the Newark Police Department reformed. So what did we do in 2011? We did many interviews with community members, with police officers at every level of the force, union representatives, other law enforcement agencies, the public defenders, clergy, elected representatives, and we heard many different voices about what was wrong with the police department. We reviewed thousands and thousands of documents, as you got a sense from David of how incredibly document intensive these kinds of investigations can be. It's not like the federal government actually has a whole lot of resources that people think we seem to have. This was like a lot of spit and bubble gum and shoestring, pulling it all together. But we did analyze training records, IA files, arrest reports, use of force reports, and we hired experts from around the country from other police departments to help us do the analysis. We went on ride-alongs, we toured cell blocks, we toured the property rooms, and we even attended some internal affairs hearings to get a sense of what was going on. And after a very intensive 3-year-long investigation, we were able to announce our findings in 2014, and I want to go through with you what those findings were. With regard to stops and arrests, for every stop, the Newark Police Department is supposed to fill out a field inquiry report. Well, there were 39,308 of those between 2009 and 2012 that we looked at. We found that 16% gave no reason whatsoever for the stop. We put those to the side and didn't look at them any further. The other 84%, we found 75% of them did not articulate reasonable suspicion. 75%, either because there was no reasonable suspicion, there was no reason to stop this person, or because the officers were challenged, they didn't understand the law, they can't articulate it in their written reports, or they used a lot of sort of vague and conclusory statements in their reports. And the supervisors, whose job it is to read the reports, were providing no check or balance or training. They weren't sending the reports back to the officers saying, this is insufficient, you have to fix this. Let me give you training to make sure you know how to do this, so that I really know that you understand reasonable suspicion. That simply wasn't happening. What we found is that people were stopped for milling, loitering, or wandering without any reasonable suspicion of criminal activity. It seemed as though living or being in a high crime neighborhood was enough. So what else did we find? We found people were arrested for lawfully objecting to police action, taking pictures of police or videos of police action, as it is their First Amendment right to do if they're not interfering with police action. We found they were being arrested. People were being arrested for simply mouthing off to the police. And they were arrested for disorderly conduct or resisting arrest, when in fact they were spitting or mouthing off. We found that many narcotics arrests, there was also no articulation of probable cause. And again, we don't know if it's because the officers don't understand what probable cause is, can't articulate it in a report, but certainly their supervisors were not checking to ensure that these reports were done well. Use of force was also something else that we found to be a bit shocking. In more than 20% of the use of force incidents we reviewed between about 2009 and 2012, 20% the use of force appeared unreasonable and in violation of the Constitution. There was a lot of underreporting of force by police officers where they would use force in an interaction with a civilian, but they wouldn't write a report about it, so we couldn't even review it. Many of the reports were vague and very not, and really not descriptive. No corrective measures could be taken. The IA process was completely broken. When you look at the IA review of civilian complaints of excessive force, out of the hundreds and hundreds of complaints received between 2007 and 2012, there was only one sustained finding of the use of unreasonable force. There's no right number that should be sustained, there's no wrong number that should be sustained, but one is definitely a indicia of a really dysfunctional accountability system. Another sort of shocking thing that we learned about the IA process was that when the Internal Affairs Division thought that an officer's conduct might be criminal, they would refer it to the Essex County Prosecutor's Office for an analysis to see if the Essex County Prosecutor would like to charge the officer with a crime. And during that time period, the IA process would be sort of administratively stopped. The Essex County Prosecutor's Office would then look at these cases, decide whether these officers should be charged. They would charge some, but the vast majority, they would say, this doesn't rise to the level of a crime, or we can't prove this beyond a reasonable doubt. We're going to send these files back to IA. Once those files went back to IA, nothing was done with them. They did not restart the administrative process. So there was this swath of officers' conduct which wasn't charged criminally and wasn't dealt with administratively, but was serious enough that the internal affairs people thought it should be looked at criminally, and nothing was ever done with those files. We found that in the IA process, the officers were deemed credible regardless of their past disciplinary conduct, but citizens were deemed incredible based on their criminal history. Every citizen who came forward to give a complaint to IA, regardless of whether they were arrested in a criminal case or not, were given Miranda warnings. Even witnesses were given Miranda warnings. Now, I understand if someone's been charged with a crime and they're represented by counsel and they're filing a complaint with IA, they're represented by counsel and they should not be interviewed by officers about the incident without at least their counsel knowing about it or being there or signing off on it. And I get that. If they're in custody, they should be Mirandized. But citizens who aren't under arrest were being Mirandized before they could give their side of the story and why they were complaining to IA. And witnesses were too. And that had a real chilling effect because people didn't want to complain to IA. Would you, if you were going to be Mirandized? It just was completely unnecessary, made no sense, and had a chilling effect. So the IA process, we found, was also unfair to the police officers because it seemed really arbitrary. The penalties were arbitrary, and there seemed to be no mechanism to ensure any disciplinary fairness, and there seemed to be quite a lot of favoritism at play. The cell block at Green Street was deplorable, particularly from the aspect of suicide prevention. The guards were not trained in suicide prevention, and the way it was physically set up, it made suicides hard to detect and prevent. We also found that officers were not sensitive in terms of gender-biased policing. There was inadequate training of them to deal with sexual assault victims. Same was true with their interactions with the LGBT community. No sensitivity training. And finally, property theft. The Newark Police Department knew that there was a problem with theft by officers from the property room of arrestees' cell phones, wallets, watches, jewelry, etc. They also knew that there was a problem with theft from the evidence room, and they actually tried to get their arms around this problem. They put up video cameras right outside the property room and caught on video a supervisor in the property room disabling the camera. A supervisor and an officer who disabled the camera in the property room were never disciplined for it. I believe the supervisor was allowed to retire, and the other individual left the force for unrelated reasons. So what did we do with this, and how long have I dragged on? Because I'm really only halfway there.
Keep going. You're doing fine.
Literally, we are 6 years into what I hope is only a 10, 11, or 12-year reform process. In 2014, we released our findings and basically told everyone what we'd found. We also had, thank goodness, willing partners in the mayor's office and in the police department who wanted to engage in reform. And so on the day that we released our findings, we released an agreement in principle, which was a 12 or 13-page document that set forth what the police department in the city promised to fix. And that became the backbone of our written consent decree, which we released in March of 2016. When I say willing participants, what I mean is that over the past 6 years, we've had 3 different mayors and 4 different police directors. And thank goodness they have been willing to engage with us, because we can't do the reform process alone. But as you could probably imagine, changes in administration can cause us a little bit of worry, can cause us a little bit of delay in the process, because we just want to move forward with an understanding with our partners of the reforms that we think need to be done. So now we have Mayor Ras Baraka and Police Director Anthony Ambrose, and they do seem to be very willing partners. Our consent decree, in the consent decree, we appointed a monitor. Jointly with the city, we selected this monitor. We solicited applications. We got about 21 applications. We had many, many interviews, after which we selected Peter Harvey from the law firm of Patterson Belknap in New York. Peter Harvey is no stranger to New Jersey. He's our former New Jersey Attorney General. He was also the first Assistant Attorney General, and he led the New Jersey Attorney General's office when that office was working on the consent decree with the Department of Justice for the New Jersey State Police. So he's also familiar with how consent decrees work. So it's really only been in the past 2 or 3 months that Mr. Harvey has been able to assemble his team of monitors and to propose what will be a 5-year monitoring plan. So David is 4 years into his monitoring plan, and we're about 4 months into ours. But let me tell you what we are already beginning to see, which is exciting. But again, I feel like it's a 5-year process, because we think it's going to take about 3 years for reform to take root and for institutional changes to be made. And we then want to see at least a 2-year period of consistent reform going forward before we feel like the city is definitely on the right path. So what is the police department already doing? And what is the monitor already doing? They are reassessing staffing department-wide with an eye towards deploying officers to support community policing. They're surveying community members. They've already trained all officers on the consent decree and what it means, and they've started training the officers on community policing. They have created a proposed disciplinary matrix for internal affairs. They are reviewing software enhancement for an early warning system, because previously there was no accountability and no check on officers who had repeated infractions. So if an officer was assigned to the property room, but he had 50 IA complaints against him for theft, nobody ever thought to maybe rotate him out of that department.
Wouldn't want to interfere with that.
So they are investing in software that will help them better track early warning systems so that they can rotate officers out. I'm really happy to say that the cell block that was so problematic from a suicide prevention standpoint is being closed, and there's a brand new state-of-the-art central processing and cell block unit opening up. And so there are 5 different precincts in the city, each had their own cell block. Now every arrested individual will be brought to one centralized cell block where they will have a prosecutor on duty 24/7. They'll have someone from internal affairs on duty 24/7, and they have ensured, hopefully, that suicides can be prevented structurally, and they're going to train the staff who works in the cell block to be on the lookout for people who may be prone to attempting suicide. The same is true with the property and evidence rooms, new staffing, more staffing, cameras, signage. The police director wants to ensure that the officers who are put in the evidence room, the property room, and in the cell block are not put there as a form of punishment as they had been in the past. They were really sort of sending not the cream of the crop to those duties, and they are going to try to ensure that it is a tour of duty just like any other, and people are not going there as a form of punishment. Citizens are going to be surveyed about their contacts with the police. Internal Affairs is moving out of a police department building into a private building located elsewhere in the city, so people will not feel intimidated about going there. And by 2018, all uniformed officers and all marked cars will have cameras. Real reform takes time. As I said, we're about 6 years into what I hope is a 10, 11, or 12-year process. Hopefully, I will be around to see it through, and I'm happy to take questions. Thank you.
Well, thank you very much. Before I open up the floor for questions, I want to ask one, which is the two of you were talking about different examples of litigation as a form of achieving police accountability and reform. What does it mean that both cities immediately agreed to settle? So this was not typical litigation in the sense that you go and you have a trial and you fight things out. What does it mean in terms of your views of those police departments and for the tool of litigation as a police accountability strategy more broadly?
I should have mentioned that, yes, we litigated for one day because we filed our consent decree in court on the day we settled the matter. So, of course, we have a federal district judge, Madeline Cox-Arleo, assigned to the case. She is officially appointed a monitor, and the parties will go to her throughout the next 5 years. She will be reviewing the monitor's reports. But what does it mean to us that the city was willing to engage with us, not just the day we signed the consent decree, but very early on? It means a lot, because we actually could not have done this investigation without the city. Short of filing a lawsuit, we have no discovery power to get documents. The city had to willingly give us all the documents that we reviewed. So having a willing partner was really everything to us. It helped us make the case, and it helped us pave the way forward. But I'm not sure that you can do this successfully without the willing partner, but I also just haven't experienced that model.
Yeah, I think it's necessary, but not sufficient. We had an administration, once we notified them that we were going to file suit, shared a copy of the complaint with it, actually filed, and then we agreed on a consent decree. I think the city knew that they had expanded stop and frisk without any oversight, any accountability, and knew it was a problem, and I think wisely decided not to litigate and to try to reform it. So certainly credit on that level. That was 2011, 2012. But that's, even with that, it's not enough for the mayor and commissioner to say, you're right, we've got to, control this better, we've got to train better, we've got to hold officers accountable if they violate the rules. It's easy to say that, that's what they said. I think they were a little bit shocked at what the data, when we rolled that, actually showed. And, this point about the length of time it takes, 4 years, 6 years, 10 years, and DOJ has a number of these lawsuits around the country, consent decrees with a lot of police departments in different cities, New Orleans, Puerto Rico, San Francisco. Really, what has to change is that culture. And even when the police commissioner says, yes, change it, even when the mayor says, yes, change it, for that to seep down into the rank and file is a huge problem. And it takes more than just the data, it takes accountability measures. And I think we started to see some progress in Philadelphia only when the department said, after the numbers weren't going down very much in terms of impermissible stops, even with a lot of new training and new directives, of holding not only officers, but I think more importantly, sergeants and lieutenants accountable, right? That somebody's got to be reviewing this on a daily basis, calling officers in, as we said, when you didn't give a reason for the stop, or you gave a reason that doesn't make sense, what's this about? And ultimately, if a sergeant knows he's on the hook, if his officers aren't doing the right thing, the officers will do the right thing, right? That's the nature of policing. But all of that, you obviously buy-in. You need a buy-in from the mayor and police commissioner. But none of these reforms will actually take root and be long-standing unless the police on the beat actually think they make sense as well. It's not going to happen, and a court's not going to be able to control it.
Yeah.
Ultimately, it's got to come from within.
All right, open it up for questions.
Hi, I'm from Chicago, and as you may know, Gary McCarthy was probably the superintendent during some of the time that you were looking at, and then took his talents to Chicago and brought with him a very aggressive stop and frisk. About a year plus ago, the ACLU threatened a similar kind of suit that happened in Philly, and there was an agreement up front to go from basically an index card, investigatory stop card, we call them, I can't remember now, we call them, to a two-page. What's happened in the wake of that is the level of police activity has plummeted exponentially. Year over year, month by month, arrests are down, investigatory stops are down. Now, some would argue that that's because they're now engaging in constitutional policing, but at the same time, we've seen really unprecedented spikes in violence in our city. So my question is, based on your experience, how do you define success? And you talked about, you've got to have the city and the superintendent on board. I think you've got to have the rank and file on board, because what I worry about in Chicago is that the police have stopped engaging in proactive policing. And that's not entirely true. We've taken 6,000 illegal guns off the street. But there's something that's happening. And some of it clearly has to do with the level of scrutiny. We've got a Department of Justice investigation ongoing, huge outcry over police activities. So how do you strike the right balance between avoiding some of the parade of horribles that you described, which frankly sound like a third world country, and not going so far that the police stop doing their job?
That's an excellent question. We haven't, I don't think in Newark, seen an increase in crime or a reduction in arrests, but we are so newly into this that who knows what the data may suggest later. I've been surprised by the level of support that the consent decree has received from police union leaders. I think that they did view the way the police department was being run as arbitrary and unfair to the vast majority of officers. They seem to want training. The officers want to wear body cameras. They feel it protects them as it protects the citizens. And so I don't think that we have seen that kind of a potential attitude shift. But I also have to say, after our investigation, we found the vast majority of police officers were upstanding, hardworking people who just wanted to do right by the city, and there were some bad apples who were not being held accountable at all. So I'm hoping that with training and also with increasing the number of officers on the force, that morale will not plummet and it will not cause any adverse consequences. In, I believe it was 2010, this force, which is about 1,000 officers, had about 167 layoffs due to budget cuts and never really recovered. But now I think the mayor is committed to trying to grow the force as much as he can, and I think with an infusion of new officers, it will really help, combined with training.
Yeah, I mean, the question puts the finger on you're right, the heartbeat of this debate about stop and frisk and other means of proactive policing and policing generally. And if we start protecting rights too much, are police going to pull back? Are we going to miss opportunities to reduce crime? I think of the stop and frisk area, there is that risk, but if it's done right, not much of one. So for example, in Philadelphia, the other thing that struck me about looking at all this data, we think about stop and frisk as a method to stop violent crime and to get guns off the street. 90%, and I'm not exaggerating, 90% of the forms we read are quality of life stops. They have nothing to do with violence. It's somebody who might be breaking curfew. It's someone who's urinating in an alley. It's someone who's got an open alcohol bottle. I mean, I'm struck by the low level of if you want to call it crime that police are intervening on. About 10% are reports of possible serious crimes or weapons. And so, I think we got to be more surgical. I think it's a useful tool. It can be useful in controlling crime. But when it's overused, we see what happens both in terms of racial bias and community reaction. And the other side of that coin, it's something we both talked about a little bit, is what I call procedural justice. What strikes me and what makes people so angry when they're stopped is not being given an explanation as to why they're stopped. More than the fact that they may have been stopped legitimately or not, I can't tell you of the number of clients and other people I've talked to where they describe a stop and I say, okay, you were stopped, what happened? The officer stopped me, frisked me, didn't find anything. He said, you're on your way. I said, why'd you stop me? If you keep running your mouth, I'm gonna run you in, right? So instead of saying, sorry, we got a description of a person, right, that just committed the robbery and he looks like you and that's why we stopped you. Glad it wasn't you, you're on your way, right? An inability, right? Literally an inability to even explain, much less apologize, right? And that's got to change. I mean, if you give somebody an explanation, even if it's a stop where somebody's innocent, they'll understand it, right? And they'll say, okay. And that's why I raised that question on this trade-off between effectiveness, and it certainly can be effective, and the harm it can do in police-community relations. If a neighborhood thinks they're being stopped unfairly, they're not going to cooperate with the police. They're not going to give the police information about that murder, right, that occurred around the corner. And I think that's the tension. But it's a tension I think you can solve with good policing. Chicago, I know. Chicago's got a terrible problem. The homicide rate is through the roof. You've got this sense of police not policing. Other cities like New York and Philadelphia, the stop rate is down, and so is crime. So, hard to kind of make any conclusions from that.
All right, and as much as I hate to do this, we're at the end of our panel. There's no break between panels, but let me take this moment to thank our panelists here.